All right, well, thank you for coming to this last session of the Property Pick and Mix webinar series. My name's Nathan Smith. I'm a barrister at King's Chambers, and I deal with lots of property and commercial law related issues. I'm going to talk to you today about two Supreme Court decisions, two fairly recent decisions, and I'm going to talk to you about them in about 30 minutes or less. So from that alone, it should be clear that we'll be going at a fairly rapid pace. Both decisions deal with the enforcement of leasehold covenants, albeit in very different situations. The first decision is the case of Duval and 11 to 13 Randolph Court. That was a decision that was handed down in May of this year. And then there's a second decision from August called Peninsula Securities and Dunnes Stores Bangor Limited. That deals with the doctrine of restraint of trade, so a fairly important issue. There is, in fact, a third case that I'm not going to talk about today, but that came out at the beginning of November that's just worth being aware of, and that's the Alexander Devine Children's Cancer Trust case, which is, I think it's one of the only decisions of the Supreme Court to consider applications to vary or discharge covenants under Section 84 of the Law of Property Act. So this year's been quite eventful as far as leasehold covenants are concerned, at least, and their appearance in Supreme Court decisions. I'm also conscious that I've been given the graveyard shift in the day of talks, so I will try to be as concise as I can. I was once given a piece of advice about talks, either to be funny or to be brief, but since the subject matter doesn't lend itself overly to jokes, I'll promise to finish well within my 30-minute slot. So the first decision, Duval and Randolph Court. Now, what was the issue in this case? Well, the question was, can a landlord in a block of flats grant a license to a lessee to carry out work which, but for the license, would breach a covenant in the lease, and which the lessees of other flats can require the landlord to enforce. So there's quite a bit to that issue, but as both the Court of Appeal and the Supreme Court observed, such covenants are in fact very common, and so this issue is a really important one. What were the facts of this case? Now, the dispute concerned leases of flats in 11 to 13 Randolph Crescent in Maida Vale, and all of the leases had similar or if not identical covenants in them, which governed the works that could be done to the building. There was a qualified covenant in clause 2.6, which made clear that tenants couldn't carry out any alterations to the demised premises without the written consent of the landlord. There was an absolute covenant in clause 2.7, which prevented the tenants or any tenant from destroying, committing or permitting any destruction on the demised premises. But also, this is the important part, not injuring any roof or ceiling within or enclosing the demised premises. So there was an absolute prohibition really on damaging the structure of the building. There was also a clause 3.19, which went as follows. It said every lease shall contain similar covenants to those I've set out, and at the request of the tenant and subject to payment by the tenant or security being provided, the landlord should enforce those covenants. Now, an important part of the facts of this case, which is common in many flats, in truth, is that the demised premises included the internal parts of the flat, but not the outer load-bearing walls of the building. So the walls, the load-bearing walls, were the landlord's property. So what happened? Well, in spring of 2015, one tenant, Mrs. Winfield, approached the landlord's managing agents for a license to carry out proposed works to her flat. Those works involved removing a substantial part of a load-bearing wall at basement level. They were just modernisation works, and would have resulted in an improvement to her property. But it was common ground that that would have been a breach of clause 2.7. That's to say, the clause that prohibits damaging the structure of the building if not authorised by the landlord. Now, in the course of negotiating a licence agreement, some neighbours objected. The landlord considered those objections, considered presentations by architects, engineers, etc., but still decided to grant a licence subject to adequate insurance cover being in place. The tenants still objected, and the first decision in this case came before a deputy district judge sometime in 2017. And that judge decided that the landlord had no power to waive the covenants, that's to say, to waive the covenant at clause 2.7 without the consent of all the lessees in the flats, of the flats in the building. The landlord appealed against that decision, came before Judge Parfitt in July 2017. He held the landlord did have power to license the works, then went to the Court of Appeal. I think that was in October 2018, so a few years later. And the Court of Appeal held that even though, even in a case where other lessees hadn't made a request to enforce or provide security as required by clause 3.19, that's to say where there was a contingent obligation that the landlord may have to enforce, the Court of Appeal considered it was implicit in that the landlord wouldn't do anything that would put it out of its power to enforce the covenants. So the landlord didn't have permission. Now, the landlord appealed to the Supreme Court and argued, amongst other things, that the Court of Appeal failed to properly construe the leases in their context and had in fact ended up creating a really commercially unworkable scheme, which was a recipe for chaos in multi-tenanted buildings. And you can see what the landlord was saying there, really, because it effectively meant that any leaseholder in that building had the power to veto repairs, renovations or improvements that involved some sort of works being done to the structure of the building, however capricious or unreasonable their intentions were in objecting to them. And also, in a large block, the landlord may struggle to obtain a response from all the other leasehold owners anyway. So that was the basis upon which the appeal was put to the Supreme Court. And it's obviously a question of construction of the lease, fundamentally. So the Supreme Court reaffirmed what is by now a fairly well-known approach in Marks and Spencer's and BNP Paribas as to when terms should be implied and how to construe a lease before doing that. There's a two-stage test. The first question is, what have the parties agreed? And the second is, should a term be implied? Now, as to construction, the Supreme Court held that clause 3.19 did not contain an express prohibition on the landlord granting permission, but was there an implied term that the landlord should not do so? And in other words, can a party who undertakes a contingent obligation be put under a further obligation by implication to prevent the contingency from occurring, or indeed from putting it out of his power to discharge that obligation if the contingency arises? That's the formal way, I think, of putting it. In a way that only higher courts can, legal principle was looked for, starting in cases involving breaches of marriage contracts, eventually coming to more modern cases. But ultimately, what the Supreme Court decided was that the landlord was unable to provide consent, that routine works didn't fall within clause 2.7, and that cutting into load-bearing walls wasn't something that the landlord could consent to, notwithstanding that the landlord in fact owned the walls. An important part of the background with the construction of the lease, as I think will be the case in many leases, was that they were long leases, 125 years, acquired for a substantial premium, and the court thought the parties would have understood that routine improvements would be needed, but equally all had a significant interest in the integrity of the building. So what are the takeaway points from this decision? Well, even where I think, authorization sought to alter part of a building owned by a landlord. The landlord may well not be able to grant permission if that's going to place the landlord in breach of other obligations to tenants. And it's ultimately a question of the construction of the lease. But as I said earlier, these covenants are fairly common. So similar covenants are likely to be interpreted in a fairly similar way. And I suppose the other point to take away is this. I mean, the Supreme Court again reiterated the test for implying a term into a lease. It must be necessary to give business efficacy, or so obvious that it goes without saying, and capable of clear expression. So it's not enough that a term would be reasonable to imply, it has to be necessary. And one interesting way, I think, of putting that test, which was the way the Supreme Court put it in Duval, was without it, would the contract lack commercial or practical coherence? And in this case, the Supreme Court said that it would. So I think an interesting case there for landlords, not just of blocks of flats, but also on any development really where there's the potential for works to common parts. What about the second case? Now, this I think is perhaps a more interesting case. This is the case of Peninsula Securities and Dunnes Stores Bangor Limited. And it's an appeal that concerned the doctrine of restraint of trade and the extent to which it's engaged by restrictive covenants, and indeed the basis upon which it's engaged. Why is it engaged in certain cases? Now, last year, the Supreme Court considered aspects of the doctrine of restraint of trade in a case called Egon, Zender and Tillman. But that was more to do with employment contracts. And the court noted on that occasion, I think, that it didn't need to explore the outer reaches of the doctrine and how it might apply to property. But the present appeal, it was said, permits no such escape. So it had to be confronted head on. So what happened in this case? Well, there was a developer, a Mr. Shortall, who developed a shopping centre in Northern Ireland, and he leased part of that to the defendant, Dunnes Stores, a well-known retailer, and it was the anchor tenant effectively for this development. And the developer covenanted with the developer not to allow any other substantial shop to be built in the rest of the centre in competition. And in due course, he assigned his interest in the property to a company, Peninsula, which incidentally was largely owned by him, but that nothing really turns on that. And the company, over time, found the centre to be ailing and thought the covenant was stunting its ability to revive its fortunes. So it applied for a declaration that the covenant, firstly, engaged the doctrine of restraint of trade, secondly, was unreasonable, and thirdly, should therefore be unenforceable. Now, the Supreme Court only actually considered the first part of that declaration, that's to say whether or not the doctrine was engaged. And in order to do that, it had to go back some time to a case from 1968, which many people may remember or not, as a result of reading about it in law school, obviously. So what happened in Esso Petroleum? Well, this was a case where a garage entered into what's called a solace agreement with Esso at two filling stations. That meant that it could only buy petrol from Esso at those stations, one for 5 years and another for 21 years. Now, the House of Lords, when it looked at this in 1968, said that both those clauses fell within the doctrine of restraint of trade. It held that the shorter one was reasonable, the longer one wasn't. And the basis upon which it did that was a test that was developed by Lord Reed. And he said that a restrictive covenant upon land that prohibited its use for trading fell outside the doctrine unless the purchaser was surrendering a freedom that he previously enjoyed. So in this case, in Esso, the argument went that because the petrol stations were already operating with this freedom, and when the restrictive covenant was put in place, there was a surrendering of a freedom that was previously enjoyed, and so the doctrine was engaged. But equally, that test applies to things like tied public houses, where someone comes to a situation where there's already a tie. The doctrine isn't engaged because there's no surrender of a pre-existing freedom. So that decision has been subject to a fair amount of criticism over the years because it leads to strange outcomes that are logically quite hard to justify. So, for example, if all the landowners in, let's say, the northwest agree not to trade on their land, the restraint of trade doctrine would apply because the landlords are giving up a pre-existing freedom, and of course it would probably be held to be unenforceable. But if someone were to buy all the land in the same area and covenant with each seller not to trade on the land, the Esso test effectively stops the doctrine applying. So the covenants are all enforceable. But in both cases, the public interest and the parties are equally restricted and equally damaged. And so this pre-existing freedom test doesn't really have a logically defensible basis. Now, incidentally, in the Esso case, Lord Wilberforce always favoured a more pragmatic analysis under which restrictive covenants on land and tied public houses, because they'd long been viewed as exceptions to the doctrine, he said that made them in effect acceptable to public policy. And that's a test that came to be known as the trading society test. Of course, that in itself has some problems because it might just entrench unfairness that has existed as a result of years of unfairness. But anyway, when this case came to the courts, let's say the Peninsula case, it first came before Mrs. Justice McBride, and she applied the Esso Petroleum test and said that while the developer had surrendered a pre-existing freedom so that the restraint of trade doctrine would have been engaged while he owned the property, Peninsula had not, so it wasn't engaged. But the Supreme Court asked itself why logically, or indeed in terms of public policy, the doctrine should apply to the developer and not to an assignee. I mean, it had to confront this awkward question, in effect. Is the surrender of a pre-existing freedom an acceptable criterion for engagement of the doctrine? And ultimately, it decided that it wasn't. And it invoked the practice direction, which it can use in exceptional circumstances to depart from a previous House of Lords decision. And it concluded that because of those logical inconsistencies, the pre-existing freedom test wasn't a good basis for deciding whether or not the doctrine of restraint of trade was engaged, and instead decided that the trading society test, the one that had been put forward by Lord Wilberforce in the minority at the time many years ago, was a far better test. And in that decision at paragraph 46, it was said that ultimately the trading society test was more acceptable, under which the doctrine is not engaged if it is of a type, that's to say the covenant is of a type which has passed into the accepted and normal currency of commercial, or contractual or conveyancing relations, and which may therefore be taken to have assumed a form which satisfies the test of public policy. And in the case of the restrictive covenant in the shopping centre that Peninsula wanted to have declared unenforceable, it was satisfied that that sort of covenant has been in use for many years. There's nothing unusual about it. And importantly, there was no ground for considering that social changes required a re-examination of whether it should engage the doctrine. So there are two decisions there, I think, that are really quite important for leasehold covenants and their enforcement. in conclusion, the first case, Randolph Crescent, the landlord may be able or may be unable to consent to works, even to non-demised parts, if it places the landlord in breach of obligation to other tenants. And then, of course, in terms of the second case, the Peninsula case, the takeaway point is that less common or unusual covenants in conveyances may well be subject to the restraint of trade, but not if they're part of normal conveyancing or commercial practice. So, of course, even if the doctrine were to be engaged, it doesn't follow necessarily that the covenant becomes unenforceable. It still has to be unreasonable. But if you are involved, I think, in drafting or advising upon these covenants, it's an important consideration to bear in mind, especially if you're drafting or looking at something that's a bit outside normal conveyancing or commercial practice. You want to look and see whether or not that type of covenant has been subject to the doctrine previously in any way, and if not, whether or not there's some sort of societal change that might justify its inclusion within it. Anyway, that concludes what I wanted to say about those two cases. I'm a little bit ahead of time, so I've kept my promise in that regard. I personally am always slightly relieved when speakers finished slightly early. I don't have any questions either on my question and answer panel. So thank you very much for joining me. I hope you've enjoyed this talk. I hope you've enjoyed the other talks that have been put on by King's Chambers today. And good evening.